I started off in Las Vegas in 1982. I came here to work on the MGM fire case. After about a year, I went to work for now currently Justice Cherry, back then Mike Cherry, doing general practice. I also assisted him. He was the special master for the MGM litigation later on. From there, I did some insurance defense work, and later went off on my own after working for Ed Bernstein. I'm trying to remember all the, back then. In about 1990, I went on my own. I've done just about everything. When you start off, you do anything that comes through the door. I've been an arbitrator since the program started. I've also been a short trial judge since the program started. I was one of the first short trial judges. I'm sure most of you are familiar with that program. It's for jury trials for cases under $50,000. So I currently, as a matter of fact, Tuesday I have a short trial down in district court that happens to be a contract case. So we do everything. It's not just personal injury. Certainly I've done a majority of my private practice has been personal injury and workers' comp. That maybe because of that, I'm very familiar and certainly supportive of the what's commonly called Veterans Court. It helps divert veterans to programs, and because I've represented a lot of veterans doing workers' comp, injured on the job, etc., I'm a strong proponent of that program. My dad was a 20-year career Army Reserve, and my uncle was a POW in World War II. He was just recently buried at Arlington. That's basically my career.
Thank you. Let's start off with the first question with Michael Mazur.
Yes, this question goes out to the entire panel. It's a hypothetical. If you were to receive a campaign contribution from either a donor or a party that would come and appear before you, or an attorney or a firm, how would you handle that? Can you please address that?
Just to clarify, is that a donation that would come in during the campaign?
Sorry, Lucinda, could you say your name, and because it's going to be rebroadcast?
Okay, my name is Lucinda Como.
Yes, that's a contribution during the campaign prior to election.
Okay. Well, since campaign contributions are the lifeblood for us, and we do need to accept them, I think that there are limitations, the $5,000 per person in the primary cycle and then $5,000 in the general. And I think that there's nothing wrong with accepting the contribution, and you are going to be getting contributions from people who will most likely appear in your court. I do think, however, that if you are getting a lot of contributions from the same firm, a firm that you know litigates and would be in front of you on a fairly consistent basis, then I believe at some point I would think long and hard before I would continue to accept those contributions. I do think that it is a fine line we have to walk, because judges are elected and we have to campaign, and we are getting money from the people who will appear before us. But I think that, and I've thought long and hard about this, because there is that appearance of impropriety potentially. So I think that it's something that each individual candidate has to make their own decision about. But I would try to be very aware of contributions coming from the same firm, and at some point I would say, I have to stop accepting, because it's going to create the appearance of impropriety.
Well, I think the judicial canons are pretty clear. Could you,
Oh, I'm sorry.
Could you
My
state
name
your
is-
name for the people
My name is
listening at
Jack
home?
Howard again. The judicial canons are pretty direct and clear. If you cannot sit because of bias or prejudice, either for or against, you should not sit. And you should disclose the reasons for the recusal and articulate the reasons why you are recusing. Again, when you elect a judge, you expect honesty and integrity. Of course, we receive contributions from people who are going to appear before us. When I take cases, I do a conflicts check in my office, both as an arbitrator and as a mediator. So, if I can't sit with integrity, I need to recuse.
This is Ron Israel. Since I've been around here 28 years, I know probably most of the attorneys, both plaintiffs and defendants, doing litigation that are practicing out there. And I've had lunch or dinner with most all of them. I can tell you on my campaign committee, on the website, I probably have close to an equal number of plaintiffs and defendants. That doesn't mean necessarily that they're, any or all of them are going to give me money, but fortunately I'm in the position where I've spent my own money on my prior campaign. Yes, I've gotten contributions, but that's been a minor part of the campaign expense. So any donations are basically insignificant compared to what I've done. That does afford me the luxury of basically saying, hey, these contributions are insignificant to me, so I don't see how they would affect me. Now, you know, not everybody has that luxury, I understand, and it's unfortunate, but at least as far as I'm concerned, I don't see there's going to be any conflict. Nobody's going to give me enough money to influence me either way.
Thank you. Do any, Cheryl, you got a question for a specific or
I
all?
do in fact have a question for Mr. Howard. Jack, I know you basically in the family law area, so can you just, I'm just curious why you chose to run for a civil bench as opposed to a family court?
The decision was based on many reasons. You know, my expertise is litigation. And once you know the rules of evidence, it translates out, whether it be in criminal or civil or family court. I've told people at the end, I've been an arbitrator forever. I've been a mediator forever, not just on, I mean, these are civil or family cases, whatever. What I think, if you look at my bio or my resume, I've served in just about every court there is. And so when you're a judge, either you get the gig or you don't. When the arbitration was started, they solicited feedback from the participants. And I had something like a 95% approval. And those are all civil cases. So I think the problem with some of our judges, with lack of litigation background, they get bogged down, they don't know the rules of evidence, and so my attitude is I'm going to hit the floor running. Lastly, it's a lot easier dividing people's money than it is their kids.